First case on the 9 a.m. docket for Tuesday, September 10th, 2024 is appeal number 125936, State of Kansas versus Robert Lee Harris Jr., Johnson County. Briefs both sides.
May it please the court, Michael Whalen on behalf of the appellant, Robert Lee Harris, present and ready for argument.
May it please the court, plaintiff appellee of the state of Kansas by Assistant District Attorney Kendall Kaut were present and ready for argument.
Second case, appeal number 124495, State of Kansas versus Micah Teal, appellant, Saline County. Briefs both sides.
May it please the court, I'm Ryan Edinger, Assistant Appellate Defender, appearing on behalf of defendant appellant Micah Teal, present and ready for argument.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers, present.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. I want to start by thanking counsel, especially in our second case, who were flexible enough just in the last few days to change the schedule a little bit, as we had what is an unusual event in this court of a last minute removal of a case from the docket by voluntary dismissal of the appellant. So thank you for making that change for us. And it's good to see counsel, a couple of you who haven't seen for a while. So very good to see you back in our courtroom. And with that, if the attorneys in the first case 125936 would like to settle in, and then I'll continue to make some remarks as you do that. And then once we're finished, you can come to the podium. The remarks I would make are just for the audience who may not be familiar with the process and the procedures that we follow. And I would explain that when we receive a case on the docket, we receive briefs from the parties, and then we also have research memos that are done in-house. The court has reviewed those matters. We've reviewed portions or all of the record as necessary to prepare us for the argument. We have we'll be using this time to really explore questions that we have with the attorneys, which may mean we interrupt them at times as we ask questions of them. They usually are quite gracious with that, and we appreciate that because that dialogue helps us get a better understanding of the arguments that they are making. We do have notes. Many of us have them on our computer, some on paper. We will at times be consulting those. And again, just so you know that when we're looking at those, we are focused on the substance of what we're hearing. We are still listening when we do that. So with that, Mr. Whalen, if you would, if you were ready to please come forward.
May it please the court, Michael Whalen on behalf of the appellant Robert Lee Harris. A communication is testimonial if it requires an individual to disclose the content of their mind. It's from the United States Supreme Court case Doe versus United States, 487 U.S. 201, 1988. Going to be going through a couple different issues here. Mainly, we're looking at whether or not the passcode is a testimonial statement and something that therefore should be afforded Fifth Amendment protections. We'll also be looking at the specifics related to the revelation of the passcode by Mr. Harris to law enforcement and whether or not that was compelled or coerced or if his Miranda time had run out of space.
Can I just interrupt in the order in which you said it? So if, the Fifth Amendment protection would be, if it was compelled and if it was incriminating and if it was testimonial in nature. So if we address the first part, the compelled and the voluntariness, does it matter whether or not it's testimonial based on the United States Supreme Court case that says that if a Miranda warning is not given, and even if it was testimonial, that if it was voluntarily made, then the fruits of whatever the information you got, if it was voluntary, it comes in.
I believe that's a correct statement.
So would you mind starting with the voluntariness part? Or would that? mess
No,
it up?
no, that's fine. I'm
Right.
more than happy to.
Can I interrupt you for just a minute? Because
Yes, please.
although I said I would be actively listening, I may have missed if you asked for rebuttal time.
Oh, I apologize, Your Honor. I would ask for 5 minutes.
Okay, let's
With your
let's
permission.
make that adjustment if we can, Mr. Shima. Thank you.
Thank you. It's been a while since I've been here. I
Oh,
apologize.
no, I thought perhaps it was the one that had missed that, so.
Whether or not the statement was voluntary, as related to the passcode. The facts are that Mr. Harris was taken into custody, and placed in an interrogation room on, I believe the 8th in the evening. He was then, questioned by, law enforcement for about an hour and a half. He invoked his right to remain silent. He then was interrogated for another 50 minutes to.
Just to set this up correctly, you're not suggesting that by knocking on the door, there's a problem with that's a continuation of his waiver of the Miranda in that initial interview, that you're not contesting any procedural difficulty with that, is that?
No, Justice Rosen, I'm just trying
Okay.
to.
I just,
Timeline.
okay, exactly. I wanted to clarify that that's not on the table.
No, sir.
The only kind of Miranda question that's on the table is whether he should have been re-Mirandized the next day.
Yes, Your Honor.
Okay, thank you. That's fine.
Then it's unknown as to when he was how much longer he stayed in that interrogation room at the Tomahawk Ridge Center and was then taken to the jail. Approximately 3 o'clock in the afternoon on the following day, after about 17 hours since he was taken into custody, Mr. Harris was approached by Detective Melvin and another detective. And he was not given any Miranda. And in fact, Detective Melvin testified that he didn't even know that whether or not Mr. Harris had been given his Miranda rights or warnings previously. And we're not questioning whether or not the Miranda rights were given the day before. But when we look at the totality of the circumstances as it relates to whether or not he needed to be re-Mirandized, we have,
What did you just say? I'm sorry.
whether he needed to be re-Mirandized or Mirandized again before speaking with Detective Melvin.
But let's just assume for purposes of your argument that he needed to be just assume that he needed to be re-Mirandized. And so he wasn't, or even assume that he was never Mirandized. I'm just wanting to focus on the voluntariness. And I think that, we recently had a case come out, I don't know if you're familiar with it, In Re GO, which talked about, that you look at the totality of the circumstances and whether the person's will was overborne, and that you look at the details relating to the actual interrogation, and then those relating to the characteristics of the accused. And that's what we look at for voluntariness. So even if there was a Miranda violation, I just want to get to the heart of the voluntariness, because if it was voluntary, it doesn't matter whether he was Mirandized, right?
Well, I think I would disagree, because if we make the argument that it is testimonial in nature, that he should have had the protections before revealing information that could potentially incriminate him or giving access to the phone information. If we get past the Miranda issue, then we're looking at, he was in custody for at least 17 hours. There was no evidence put on by the state as to what his mental state was, whether he was sleepy, if he was in a good mental state. He was approached in an interview room in the jail. We don't know whether or not he was handcuffed or not. Detective Melvin testified he did not remember whether or not Mr. Harris was shackled or handcuffed at the time. It was then put to him, we have a warrant for your phone, give us the passcodes. And Mr. Harris, said, is this something I need an attorney for? And I said, well, that's for you to decide. And then went to him and said, look, here's the deal. You can give it to us now, or we can go and get a court order and force you to do this. And then they also said, we're going to get it from you one way or the other. And that's where we're saying the coercion, the compelling statements came in by law enforcement saying, you don't have a choice in this matter. We're getting this information, so give it to us now.
How is
Can
that
I-
different from someone, from an interrogator saying that we are gonna, they don't have a warrant and the person says you can't search my car. And they said, well, you can either give us permission or we're gonna go get a warrant.
I would argue that that is coercive in its presentation. And here, I think it goes a step beyond, we'll just go get an order from a judge. First of all, there's no precedent that sits there that's saying that a court can compel somebody to give their passcodes, because that issue has not yet been decided in Kansas. So he wasn't standing on known precedent.
Doesn't
But
that
you-
cut against your argument? I mean, I think taking us back to GEO, there's two components to our test. You have to demonstrate police overreaching. And you're suggesting the statement that we're going to get it one way or the other. I could see if our court had clearly held that no, passwords are testimonial, cannot be compelled. That maybe is an argument for police overreaching. But when it's an undecided issue, doesn't that cut against you?
No, I don't believe that it does, Justice Wall. Just because it was an overreach for the officer to say, I can go get this court order and force you to do it, because it was unknown. And it was not at that time, there was no precedent or basis for him to be able to make that assertion.
Well, hadn't he already done it in a different case?
Well,
This particular officer had in fact gotten orders from a court ordering people to give passcodes, correct?
yes, he had stated that he had done it once before, but he had never did not know of any other officer that had done it.
So doesn't that cut against your argument that he thought he was telling the truth and he had something to back it up, which was a court order in another case?
He had that belief, but it was not based upon any legally accepted parameters. It was not something that had ever been challenged before in the courts. And so I would say that for him, he's just making a statement, although he may have done it in the past, but there was not a legal basis for him to make such a claim.
But the exclusionary rule is meant to be punishment for inappropriate law enforcement behavior. It's a judge-made law that is made as a deterrent to law enforcement. Quit it. Stop doing this. So how can we justify that judge-made law to exclude obviously relevant probative evidence because he based his decision on what he understood judges did legally?
Well, I don't know that we can say that the passcode is important, knowledgeable information. The information from the phone, the police definitely wanted, but the passcode itself was a product of Mr. Harris' mental efforts.
Quite possibly just a shortcut.
Yes, ma'am.
We have two doctrines at play here, the good faith doctrine that the state relies on in arguing that the officer actually had good faith to make the statement. And then the requirement or the threshold test of was there official coercion? Are those the same, or is there territory between those two concepts? And are we following within those somewhere in that gap between those two concepts, or are we falling in one or the other of those pockets of doctrines?
I think we have with the, I think they cover, they're in a Venn diagram, I think there would be some crossover there. But with the good faith exception, I think that that does require to be some actual legal background that they were relying upon for that good faith. And I think that's what's missing here, is that this was a question that had not been addressed. And despite his prior experience with one judge, he did not have that legal basis to stand upon.
You were saying that the coercion was two things, one way or another, or we are gonna get it anyway. And then you're saying we are gonna get it anyway. There was no legal basis for that, right? That's your argument?
No,
Because it's not set
to say that
law.
I think to say that I'm going to go get a court order and make you give me this passcode is what there was no legal basis.
Fine. But on the one way or another, are you alleging that that was implying any kind of physical violence or?
No.
Okay.
No, it's just that as the statement, we're going to get it from you one way or the other is,
Okay.
is coercive within its statement.
What's your best case to show coercion? I mean, I'm kind of looking at your brief and I'm kind of having trouble aligning the arguments you're making with a particular case law support. What do you think is your best case?
Off the top of my head, Justice Biles, I don't have one to give you.
If I could real quick take you back to where you started, which is the testimonial nature of the passcode itself.
Yes, Justice.
You didn't really get a chance to flesh that out. Why is it testimonial? I mean, it seems to me the argument could be put at least that it's utterly irrelevant to any of the facts that might be required to either prove the case or disprove it.
Well, the information that's contained within the phone itself.
Sure, but that's not what we're talking about. We're talking about the passcode.
Right. We're talking about access to that information.
Access is different. I mean, that's my question. What makes that testimonial? So for example, if I could give you a hypothetical, cops show up to a house and it's a secure house. It's well locked up. They knock on the door and say, "Open up, we have a warrant." Is the person inside compelled to comply with the warrant's order to have the house searched?
No. I mean,
And then
say no, but then.
right. So then the cops say, "Look, you got a nice front door. We really don't want to mess it up. We really like you to open the door, but if you don't, we're going to smash it down." And then the person inside is like, "Well, okay, fine." Is that testimonial? It's not testimonial, is it?
It is because it's a cogent creation of the individual's mind. It is something that they have developed and put into play.
So if the front door is keyed by voice control, saying "Open Sesame," that's testimonial? Is that your argument? As opposed to simply turning the deadbolt?
If there were an actual, if the voice activated required a passcode, such as Open Sesame.
Why isn't a voice print? It's its own passcode. I mean,
Well, if the voice print, I think we run into a differentiation here potentially between a thumbprint.
well, let's say it's voice to stick as close as possible to. I mean, it sounds to me like your argument is yes, if the door only opens to the voice printed command of the owner, then that's testimonial. That sounds to me like your argument.
I think there's a distinction to be made as to whether or not there's an actual phrase that was created by the person and not just a voice print. If it's just, open door, that could still be.
But if it's a secret phrase, then it is.
Right. It would be based upon the same kind of passcode, something created by that individual in order to gain passage to the house. And there's obviously a split in most state and federal cases as to whether or not it's testimonial or not. If there are no other questions. Thank you, Your Honors.
Counsel?
May it please the court, plaintiff appellee, the state of Kansas by Assistant District Attorney Kendall Kaut. Justice Stanridge is certainly correct that there are three things required for this statement to be suppressed without getting into the good faith exception, inevitable discovery, and potentially the foregone conclusion, whether it's incriminating, compelled, and testimonial. And I at least will start with voluntary, and I know there are a variety of questions and directions this can go, so happy to address anything that this court may want to discuss with me. But the statement ultimately is voluntary in this setting because he has already been Mirandized. He knocks on the door in that first interview. When the detective comes back that next day, he's been given the Miranda within a reasonable time frame.
I don't want to derail you too much, but are you conceding that for the evidence not to be suppressed, the disclosure of the passcode has to be voluntary?
I am not, Justice
Okay,
Stegall.
it sounded like you were just a second ago, so I may have misheard you.
My apologies, Justice Stegall, for not being clear on that point. We are not. I think all three of those components would have to be
In
met.
other words, if it's not testimonial, it can be compelled.
It can't,
It's a
Justice
legal
Stegall.
process.
Exactly. The only way it maybe couldn't is if there was some due process claim. If
I mean, they can't beat it out of him, but a court could order it.
Exactly right, Justice Stegall, under our perspective on this case. Yes. And so we believe it is voluntary, given the nature of that interaction. We quote that Maddox case, which lists a variety of cases, including more than one day is appropriate to come back and not have to re-Mirandize somebody. I also think when looking at the totality of the circumstances of that interaction, it's important to note when Mr. Harris says, "Do I need a lawyer?" the officers let him know that's up to him. And in the opinion that Justice Foth writes out in the order he has for this case, he notes that the officers reacting and telling him that would be his decision shows that Mr. Harris is aware he could consult with an attorney before making the decision. He's been Mirandized and previously invoked his rights. And we know this man works at a cancer center at St. Luke's Hospital. So he's not somebody overwhelmed by the police in this instance when he reveals the passcode to them. On top of that, I think in this instance, what's also important to note is that the court could just decide this and once again sidestep the testimonial nature, the foregone conclusion doctrine, whether the good faith exception applies, and sidestep it. Certainly before getting into this issue and briefing it and arguing an oral argument, was not aware of how truly complex this could be, but I think this court was correct when it said in State versus Lemmy back in 2020, this court need not plow this ground and whether it supports the existence of error today, because, as the state argues, any possible violation of Lemmy's Fifth Amendment right in this case was undoubtedly harmless. And so that would be one issue I'd like to just discuss briefly, because I think that could also come up as a way to sidestep things. But certainly, I don't want to forego any questions about, is this testimonial or not? Was it voluntary? Does the good faith exception apply? Certainly willing to answer any of those questions as well.
So I'd like to give you a hypothetical. And that hypothetical is that someone is arrested and the Miranda rights are starting to be read, and the defendant interrupted saying, I know my Miranda rights. And so law enforcement asks him about a gun, and the defendant says, well, I'll tell you where the gun is. And then law enforcement goes and finds the gun. They seek to enter it into evidence because it's incriminating evidence. And the defendant says, you need to exclude the gun because it was found as a result of un-Mirandized statements in violation of my Fifth Amendment right to self-incrimination. What is that? Should it be suppressed?
Justice Stanridge, I think in that instance where they have not fully read the Miranda rights, you would once again look at the totality of the circumstances, the good faith exception. I think the U.S. Supreme Court may have addressed some of these issues in the past as well. I think in that instance, there'd be a colorable suppression claim. You'd have to look at everything there. But I think that'd be obviously different than this case, given they read him his Miranda rights. He knew them. But I think in that case, there's a possible suppression issue. But I think it's different than our case, given in this instance, Justice Stanridge, he was read Miranda, he'd invoked before, and then Mr. Harris personally knocked on the door and re-engaged, showing a far greater instance of the officers from Overland Park in this case actually reading Miranda rights, giving him that option, and honoring him when he did invoke and not coming back until he knocked on the door. So I think that's the difference, but I agree in that circumstance, it could indeed be different.
Well, the United States Supreme Court disagreed with you. Those are the exact facts of US versus Pantane from 2004, and said the physical evidence, the gun, did not need to be excluded, even though it was found as a result of an un-Mirandized statement, because the Miranda rule is meant to protect against self-incriminating statements, not necessarily to exclude physical evidence derived from that. So, you know, does that change your position knowing what the Supreme Court said?
Sure. So Justice Standridge, yes, it would change my position and that was the case I was thinking of, but wasn't exactly 100% on, so didn't want to say definitively in my research for this. I think that was like a 5-4 decision from the middle of the 2000s, if not mistaken.
So how is what happened here different from that?
I think the difference here is they actually honored the Miranda rights the first time.
Let's say they didn't. I want to focus on this, you know, I don't understand how the Miranda, you know, when we look at voluntariness and you look at all the totality of the circumstances and you're looking at, you know, the details of the interrogation, number 8, because there's, you know, 9 kind of things, you know, a non-exclusive list. Number 8 is involuntariness, whether the accused was informed of the right to counsel and the right against self-incrimination. So I can see where, you know, that comes in under voluntariness when you're looking at the totality of the circumstances. Otherwise, I don't really understand, given this Pantane case, I don't know how to pronounce it, but why it matters.
It may not have to matter, Justice Standridge, and I think given what you've mentioned with that case, the court doesn't have to get there. I think if it does, though, given those differences I've outlined, that would be enough as well.
Is there a presumption the statement is involuntary if they're not Mirandized and they're in custody?
Justice Wilson, I don't believe there has to be that presumption. However, if they're in custody and they're not Mirandized, it could be a custodial interrogation. In that instance, then you'd get to that framework where if it is a custodial interrogation, then we go to, is it testimonial? So it may or may not matter depending on, I think, the facts once again. I'd also would like to address again that we think this is harmless regardless. Mr. Todd at trial, and I think this is very important, conceded this is an intentional homicide. So all the jury had to decide upon from listening to the arguments of counsel, is this intentional murder or is it premeditated first-degree murder? And so as a result, with the evidence that came out, that's how it, I think, should all be framed on these questions about whether the passcode being testimonial or not mattered and what evidence came out from the phone.
Wait,
Wasn't that
I thought all the most of the premeditation evidence came from the phone, didn't it?
Justice Rosen, there's excellent evidence of premeditation on the phone, but I don't believe that's the exclusive evidence of premeditation.
What else was there? I mean, just the searches alone, I think, satisfies the premeditation element. But what else is there besides what was garnered from the phone? Just observations of the neighbors, that kind of, and his behavior, or what else is there?
Justice Rosen, exclusively the phone could have convicted him. I agree with that statement. What else we have in this case are several things. First, the testimony of the doctor who did the autopsy mentioned that Tanisha Harris had to die by strangulation. And he said the nature of a death by strangulation with petechiae, with the nature of her having blood coming out of her head from being hit by that glass object that was on the counter, means this would be a several-minute homicide. And that the nature of that shows that this is someone who's very angry, who might have planning to go through and kill someone at such a long length, and that it's not an argument. On top of that, you have evidence in this case that Ms. Harris went home over her lunch hour. Her boss and someone from HR at the bank she works at mentions that Ms. Harris only had a 30-minute lunch break she could take, and that she never was an employee who took longer than that lunch break. But we know she went home for lunch that day because she doesn't return and she's left her badge at her workstation, which would imply she comes home for some reason and then never returns from lunch, which would mean her husband would want to get her home from lunch, and that would show planning by her husband to bring her there in the first place. The texts are helpful in that instance, but even without the text, there would be plenty of evidence for premeditation. And then his actions afterwards of covering up the murder by placing her in trash bags, by driving her car near where his boyfriend lived, by dumping her in Missouri would all be evidence of somebody that didn't just get in a fight and have an intentional crime, but is somebody trying to cover up his tracks. So those three things would show beyond a reasonable doubt why this would be harmless, Justice Rosen. If there are no additional questions, I would yield my time, but I know with the complexity of this issue, there may be some others on testimonial, foregone conclusion, and I'd certainly be willing to answer any of those questions.
Well, is it the state's position that this is not testimonial?
Justice Stiegel, you're correct.
Can you just summarize your argument briefly?
I will certainly attempt to, given the complexity of it, Justice Stiegel. Our argument there would be in line with the Southern District of New York, that there is a distinction between the passcode itself and the contents of the phone. So revealing a passcode would be more analogous, as you asked, Justice Stiegel, to voice commands or handwriting, that it's just a quick 6-digit number, and it's the contents of the phone itself that would be testimonial, and there's a distinction there. So the Southern District has agreed with that kind of line of thought, in contrast to some other courts that have said, well, that is the content of the mind directly. We're just going to say that's a literal statement and go there. So that'd be one part of our argument. The second part of our argument would be that foregone conclusion doctrine, that because Mr. Harris is on his phone, that the state or any government could establish that is indeed his phone. And we know there would be some messaging on the phone since he's looking into it. And under the foregone conclusion doctrine, then the state would be able to get access to it. And that would be based on those two U.S. Supreme Court cases. Certainly, that's a very complex doctrine. Different courts disagree on it. I don't think the Kansas Supreme Court has ever addressed that from my review of looking at Westlaw and what I've been able to find. But that would be a secondary argument to the testimonial nature of the phone as well.
Because you could subpoena the cell provider and get that data through the carrier. Is that the inevitable discovery? Is that the argument? You're not suggesting that it's inevitable because it could be compelled, because that argument depends on it, whether or not it's testimonial, right?
We are not suggesting that, Justice Wall. I think the argument here would be the foregone conclusion doctrine should be read to say, if you know files exist and have some basis for it, then a government agency, whether the state here or the federal government trying to get tax documents from an accountant in that original case could do it, but not necessarily the phone carrier, although that could be one argument for another.
What is the basis then? I guess that's what I'm trying to understand.
Sure. Justice Wall, the basis is simply if a governing agency knows the documents exist, they would then have a right to get them under the foregone conclusion doctrine for the passcode. That would be the basis that I've been able to surmise for how that doctrine would apply.
In this exact case, didn't the government have the right to obtain the information in the phone? There was a warrant, right?
Justice Stiegel, a warrant had been issued before by Judge Welch.
And given that, does it matter for the testimonial, not testimonial legal question? Does it matter factually whether or not the government could have forced and broken down the front door, in other words?
Justice Stiegel, we think it does not, because ultimately we think the state could have gone back and gotten that second warrant. Judge Foth didn't issue one for the passcode or an order for the passcode, but given there was a warrant for the contents of it.
I guess what I'm asking is, does it matter if the government had the capability of breaking the lock on the phone?
It could matter, Justice Stiegel, as another alternative to saying that could be inevitably discovered. And that gets into the Cellbrite data. We quoted from that New York Times story that said 6-digit iPhone passcodes can normally be broken in about 11 hours. And that gets into algorithms can figure out that if you have certain digits, they're more likely.
Right, but what I know all that, but what I'm trying to figure out is whether that fact matters legally. In other words, if this was a super technologically proficient person who essentially had an unbreakable code on their phone, would that matter as to the question, the legal question of is it testimonial or not?
Justice Stiegel, that question would not matter, testimonial or not. I think that gets into inevitable discovery and how the court would want to view breaking into the phone. I think testimonial or not just relates to, is a passcode a small blip that gives you access to it more akin to a key, as opposed to, is the passcode testimonial or not? So I think it's a prerequisite question to whether you get to inevitable discovery and the breaking into the phone.
Okay.
And how you come down on that question.
Ask about the foregone conclusion, because that is very complicated. And I want to make sure that I understand your argument. What you're saying is, in this case, applying SCOTUS, that that the law enforcement had reason to believe, I guess, that he would be searching for ways to kill his wife without, because that's, you know, was the premeditation, that they had reason to believe that would be on his phone?
And Chief Justice Lucas, I see my time is about up. May I have time to answer that question?
Yes.
Thank you, Your Honor. Justice Stanridge, I don't think the foregone conclusion doctrine is that narrow to say they knew he'd have searches about trash bags or things like that. It would simply say, because he has a cell phone, because the police see him on it at the time they're near him, there'd be some messages about his activity that day.
Why
But
would they see?
because I think it relates to the nature of cell phones, that people use them, they communicate, he's on the phone. So there could be some messages on there about his activities that day. And as we mentioned in our brief, it could be exculpatory evidence too, to show, hey, I never was at Walmart, or I never was in these spots. I was just at home all day. I couldn't have moved the body. If she's not here, that exculpates me too.
What is the standard of proof for foregone conclusion? Is it reasonable suspicion or probable cause or what?
Justice Stanridge, I don't believe there's a standard for the police have to believe or not. I think it's that the government agency has to show there is a basis to believe documents or something exists related to a case. And I think because there are only those two US Supreme Court decisions, and the last one is, I think, now a quarter century old, we don't have a lot of guidance on it. And so that's why certainly if it gets to testimonial communication, then the foregone conclusion doctrine, without harmlessness, without inevitable discovery, we're certainly in a very complicated world of trying to figure out exactly what the contours of it mean.
Thank you.
Thank you. And if there are no additional questions, Chief Justice Lucas and Your Honors, we would simply ask this court to affirm the judgment of the jury and ultimately affirm the judgment of Judge Foth. Thank you.
Thank you. Mr. Whalen, you reserve 5 minutes.
I just want to touch on a couple of issues that came up with counsel. I would agree, Justice Stegall, that there was very little evidence of premeditation outside of the phone itself. Even the nature of the suffocation, the coroner testified that it could have occurred by him from somebody sitting on her chest and restricting her ability to breathe, which was what Mr. Harris's statement was to law enforcement. So we don't have any other preparations, and his statement to police was this was something that came up out of a fight between the two of them that got violent. They wrestled and she attacked him with a vase and some other issues. So I think that is something that would be missing. The foregone conclusion doctrine, I read it the same way I believe that you do, Justice Stanridge, in that the state has to have some knowledge of what information is contained in the documents that they're trying to, that they're saying it's a foregone conclusion, we'll get these. As long as he admits that they're his, we know what they are, we can get them, because that was the situation with the tax documents that they got from the accountant. So I would say that I don't believe the foregone conclusion argument applies necessarily in this matter as it relates to those issues. Those were the main issues that I wanted to address, and unless the court has other questions, I would yield the rest of my rebuttal time.
I see no questions. Thank you.
Thank you, Your Honors.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.